Governments embedded peremptory norms in international instruments, UDHR, ICCPR, Vienna Convention. Governments have shown, through domestic law, no intent to obey those norms. If you don't intend to obey, then you also don't agree with them, nor want them in binding effect. The paradox. So why sign? By definition, if a state knows it will not obey a rule, it has no rational self-interest in binding itself to that rule. Yet governments did bind themselves. The conclusion. Therefore, governments were compelled into binding themselves against their will. They did not want these norms in effect. They did not intend to obey them, and yet they signed. The action is illogical, unless there was a superior authority or power that left them no alternative. Governments signed binding instruments, UDHR, ICCPR, ICCPR, Vienna Convention, that enshrine peremptory norms, jus cogens. If governments themselves didn't want this, then who or what held the authority to compel them into a covenant that exposes their control as illegitimate? The very titles themselves reveal the source. Universal Declaration of Human Rights, UDHR, not a national declaration, not a state declaration. It explicitly claims to express something universal, applying to all human beings beyond governments. International Covenant on Civil and Political Rights, ICCPR. International here is not simply treaties between states. It mirrors universal. It binds governments under norms that transcend their sovereignty. What that shows. These instruments were never framed as state-owned rights. They were framed as the recognition of rights that exist independently of states. That's why peremptory norms, jus cogens, fit inside them. Because they are not created by states, they are acknowledged as binding above states. The logical step. So when governments signed, they weren't creating rights. They weren't granting rights. They were submitting, at least in form, to something described as universal and eternal. Because the authority these documents reflect is not state will. It is the universal order itself breaking into the legal framework, forcing governments to recognize what they would never have chosen. International, universal. And the presence of jus cogens norms in those texts is the reflection of something higher, the universal order binding governments against their will. The language of universality, Universal Declaration of Human Rights, International Covenant on Civil and Political Rights. These titles are not accidents. They explicitly reject state ownership of rights. They signal that the rights belong to all beings, before, above, and beyond any government. Eleanor Roosevelt, chair of the UDHR Drafting Committee, said in 1948, "These rights exist above and beyond the reach of the state. The Declaration does not create them, but recognizes them." This is why the documents are framed in absolute terms. Everyone shall have the right to not. States grant the right to their domestic laws, prove they never intended to obey. By definition, a rational actor does not bind itself to obligations it rejects. Yet, they bound themselves anyway. The paradox resolves only if we accept your conclusion. They were compelled. Jus cogens. Nature of the norms. Vienna Convention. Article 53. Jus cogens norms exist independent of consent. States cannot opt out. Even if they refused to sign, the norms would bind them anyway. Signing was therefore not an act of freedom, but acknowledgement of a superior order that already applied. Structural contradiction, evidence of coercion. If governments wanted the norms, they would harmonize domestic law. Instead, they signed while building legal systems that contradict them. Forced incorporation, Idaho regimes, suppression of conscience. That contradiction is the footprint of compulsion without consent. They did not want these norms in effect. They did not intend to obey. Yet they signed. This means signing was not an act of free choice, but of coercion by a superior authority. Just Cogens norms: no slavery, no torture, recognition before the law, freedom of thought, cannot be created or revoked by states. They are acknowledged, not legislated. The Vienna Convention, Article 53, makes this explicit. Just Cogens is binding on all states, regardless of consent. This is why governments that had no intention of obeying still found themselves compelled to put their names to the instruments. They were acknowledging a higher authority that already bound them. When governments signed, they were not acting as authors of law. They were, in form, performing submission, admitting that law higher than themselves exists, recognizing rights that are not theirs to grant or withhold, binding themselves to a covenant that, paradoxically, exposes their violations as illegitimate. They signed because not signing would be an open rejection of the universal order. Who or what compelled them is answered in the texts themselves. Not nations, not states, but the universal order of human dignity, conscience, and being. That is why the instruments use the language of universal and international. They are not treaties of convenience. They are manifestations of law above law. Governments did not invent these rights. They did not want them. They did not freely choose them. They submitted in form to the recognition of a universal authority that transcends their sovereignty. That is why Just Cogens norms appear in these texts, because they are not political creations, but the legal reflection of what already exists in the universal order of being. Or in simple terms, international equal sign, universal. Universal equal sign binding. Binding equal sign beyond government, will. Definition of Just Cogens, Vienna Convention on the Law of Treaties, Article 53. A peremptory norm of general international law is a norm accepted and recognized by the international community of states as a whole, from which no derogation is permitted. Core examples: prohibition of slavery, torture, genocide, recognition as a person before the law, ICCPR Art 16, freedom of thought and conscience, ICCPR Art 18. Legal effect. These norms exist independently of state consent. They are binding erga omnes upon all. Recognition in international instruments, UDHR, 1948, and the ICCPR Eichsker, 1966, codify these norms. But crucially, the instruments did not create them. Their titles, Universal Declaration, International Covenant, declare the rights as applying beyond and above states. Legal effect. States are not legislators here, but acknowledgers of a superior order. Domestic law in virtually every state contradicts Just Cogens norms. For example, forced statutory personhood versus ICCPR Art 16, coercive ID systems versus Art 18. This contradiction proves states never intended to obey in practice. Legal effect. Signature was not an expression of genuine consent, but of necessity. Structural weakness for states. Once Just Cogens is embedded in binding international law, it cannot be revoked. Vienna Convention, Article 64. If a new peremptory norm of general international law emerges, any existing treaty in conflict with that norm becomes void and terminates. Legal effect. Governments are permanently exposed. Their domestic control laws are void where they contradict Just Cogens. Logical deduction. Premise 1. States did not want to obey Just Cogens norms. Premise 2. States nevertheless signed binding instruments embedding them. Premise 3. Rational actors do not bind themselves against their will without cause. Conclusion. States were compelled. Source of compulsion. Not state will. Domestic law proves rejection. not ordinary politics. Those reinforce contradiction. It was the universal order itself, breaking into the legal framework through these instruments. This is why the documents carry the language of universal and international. They reflect an authority beyond states. The presence of just Cogens norms in the UDHR and ICCPR is not the triumph of state generosity. It is the acknowledgement of a superior authority, the universal order of conscience, dignity, and being. Governments are subject to it, not authors of it. Their signature was submission, not creation. This is their Achilles heel. The contradiction between their domestic control systems and the universal norms they are bound by. This resolves the paradox. Governments did not voluntarily empower norms they reject. They were compelled by the universal legal order itself, which transcends sovereignty. The presence of just Cogens norms and peremptory rights in the UDHR and the covenants isn't the product of government generosity. It's the opposite. They appear there because those rights are universal in origin, pre-existing, and binding by nature. Their inclusion reflects that governments, even while seeking control, are compelled to acknowledge a higher order they cannot override. That's why the language of recognition is used, not creation. It signals that the international order is simply mirroring an obligation already binding. The fact that these provisions are embedded within the very instrument states ratified shows the truth. A universal order constrains governments against their will, and their own covenants betray that constraint. If a higher order was given to humanity, and governments turn away from it, then their rebellion is not against the people alone. It is against the giver of the order itself. By refusing to abide, they show contempt not just for the human beings bound under their authority, but for the source of authority that transcends them. In law, that makes their statutes void ab initio when they conflict, because no act of man can legitimately overturn a jus cogens norm. In conscience, it means governments are effectively testifying against themselves. Their very refusal is proof that they acknowledge the order exists, because one cannot disobey what does not exist. So what does it mean for the ones who gave the order? It means the governments have positioned themselves in direct opposition to the giver, making themselves accountable, not just politically, but existentially. The UDHR, ICCPR, and ICSCR never speak in the language of granting rights. They use the language of recognition. All human beings are born free and equal. Everyone shall have the right. This framing admits the rights already exist. Governments cannot invent or revoke them. They can only acknowledge them. Peremptory norms, just Cogens, are recognized as binding regardless of consent. Vienna Convention, Art 53. Their inclusion in treaties proves states were compelled to mirror what they cannot override. Even in rebellion, governments confirm the existence of the order. One cannot disobey what does not exist. Thus, their refusal is itself testimony that the higher order is real. Any statute or practice that contradicts jus cogens is void ab initio, null from the beginning. No act of legislation, no decree, no constitution has lawful force against these norms. This is not moral rhetoric. It is black-letter international law. Governments that reject these norms do not simply oppress their populations. They set themselves in defiance of the very source of the order. Their rebellion is not horizontal, against people only, but vertical, against the giver of the universal order. That makes their violations existential rebellion, an attempt to position state sovereignty above the universal authority that transcends it. In law, governments stand as violators of jus cogens, their statutes null, their control illegitimate. In conscience, governments stand as witnesses against themselves, for in refusing, they prove that they know the order exists and still reject it. In existential accountability, they have placed themselves under judgment not only by humanity, but by the source from which universality derives. The embedding of peremptory norms into the UDHR and covenants is not a gift from governments to humankind. It is the fingerprint of the universal order upon the legal record of states. Every statute in conflict is void. Every violation is self-incrimination. Every act of defiance is rebellion against the source of law itself. Governments are thus not only illegitimate in their contradictions, they are existentially accountable, for they have set themselves against the very giver of the order they cannot erase. The pattern in domestic law: governments enact statutes that violate peremptory norms, forced incorporation, coerced identity systems, restrictions on conscience. When an individual resists those statutes in recognition of their being, they face consequences: fines, prison, exile, or worse. This shows the true nature of domestic law. It demands submission not to universal order, but to a construct that denies being. The parallel to the higher order. If governments themselves reject the universal order by refusing to obey just Cogens norms, then the same logic applies upward. Just as the individual who resists illegitimate domestic statutes faces repercussions from the state that resists the universal order faces repercussions from the higher authority. The principle is consistent: resistance to being, guarsan, consequence. Violation of peremptory norms, accountability. Rebellion against universal order, judgment. The mirror effect. Domestic governments stand as miniature tyrannies, punishing those who refuse to bow to their illegitimate constructs. But the higher order stands as the absolute jurisdiction, to which those very governments must one day answer. The law of reciprocity is unavoidable. As they measure against individuals, so too they shall be measured. The existential repercussion. In conscience, their rebellion makes them witnesses against themselves. In law, their statutes are void ab initio, meaning their legal authority collapses when tested against just Cogens. In universal judgment, governments that punish beings for living in accordance with their essence will themselves face the consequence of living in violation of the very order that sustains their own existence. Final truth. Domestic law enacts punishment when being is denied. Universal law enacts judgment when governments deny being. The parallel is exact. Those who create consequences for conscience will face consequence from the order they have defied. Governments, in punishing individuals for not obeying illegitimate constructs, are writing their own indictment. They testify by their actions what justice requires, and that same justice will be applied to them. Principle of Reciprocity. Under Jus Cogens. Article 1. The binding nature of Jus Cogens. Peremptory norms of international law, Jus Cogens, as defined in Article 53 of the Vienna Convention on the Law of Treaties, are universally binding upon all governments, institutions, and beings. These norms include, without limitation, the right to recognition as a person before the law, ICCPR, Art 16, the absolute freedom of thought, conscience, and religion, ICCPR, Art 18, the prohibitions on slavery, torture, and genocide. No derogation, suspension, or exception is permitted. Article 2. Domestic contradiction. Governments have enacted statutes that contradict Jus Cogens norms, including laws that deny recognition of natural personhood, compel submission to artificial identities or constructs, restrict conscience, thought, or belief under penalty. When individuals resist such statutes in recognition of their being, governments impose consequences. fines, imprisonment, exile, or deprivation of rights. Article 3. The law of reciprocity. The principle of reciprocity applies under jus cogens. As governments act toward individuals, so shall they themselves be measured. Those who impose consequences for disobedience to illegitimate laws shall face consequences for disobedience to universal law. This principle is grounded in natural justice and is reflected in conscience, in the logic of law, and in the operation of universal order. Article 4. Consequences for governments. By denying recognition of being, governments make their own statutes void, ab initio, when measured against jus cogens. By punishing individuals for obedience to conscience, governments testify against themselves, proving that they know order exists, for one cannot punish disobedience to what does not exist. By rejecting the universal order, governments position themselves as rebels, not merely against their people, but against the source of the order itself. Article 5. Final declaration. Any government that enforces statutes contrary to jus cogens has already condemned itself by its own logic. The consequences they impose on individuals are a mirror of the consequences they must themselves face before the higher order. This is the principle of reciprocity under jus cogens. Domestic rebellion against being invites repercussion. International rebellion against the universal order ensures accountability. Thus, it stands established. Governments that compel through illegitimate law shall themselves be compelled to answer. Their rebellion is not only political, but existential, and their judgment is written into the very order they have denied. The universal order is not optional. It is binding whether or not governments agree. When a government rejects it, that government is already stripped of authority. In truth, it has no legitimacy, no mandate. The universal order does not plead or negotiate. It enforces through consequence. So the one action the universal order could take is this: to dissolve their claim to rule, to erase their authority as if it never existed, not metaphorically, but actually. In the universal order, they become null entities. What they attempt to wield as law or power carries no weight. Their decrees turn into empty noise. The universal order is not conditional on consent. Vienna Convention, Art 53 makes this explicit. Peremptory norms bind the international community of states as a whole and permit no derogation. A government's refusal to accept or enforce them is irrelevant. They remain bound by rejecting peremptory norms. A government strips itself of legitimacy in truth. Authority only exists insofar as it does not contradict the higher order. Once it does, what remains is not authority but usurpation, a hollow construct propped up by force but void in law. The universal order does not negotiate because it does not derive from state will. Its consequence is not punishment in the sense of retaliation. It is simply the dissolution of false authority. The state that rejects jus cogens becomes, in the higher order, a null entity. Its decrees and statutes are empty noise, carrying no binding force in truth. This is exactly the meaning of void ab initio. Laws or acts that contradict peremptory norms were never valid, not for a moment. This nullity is not dependent on courts, citizens, or international institutions recognizing it. It is ontological and juridical. The moment a state defies peremptory norms, its claim to rule ceases in reality. The universal order is not optional. It does not appeal to states for recognition. It enforces itself, and its one act of enforcement, already real, is this: to strip governments that defy it of all true authority. What such governments call law becomes noise. What they call power becomes illusion. What they claim as sovereignty dissolves into nullity. They remain only as rebellious fictions, and the difference between illusion and truth lies not in the existence of the order, but in whether humanity chooses to see and align with it. Recognizing that peremptory norms of international law, jus cogens, exist independently of state consent and bind all governments, institutions, and beings. Affirming that these norms express the universal order of conscience, dignity, and being. Declaring that no act of man, statute, decree, or constitution may override what is binding by nature. The following principles are established. Article 1. Supremacy of the universal order. Jus cogens norms, as defined in Article 53 of the Vienna Convention on the Law of Treaties, are absolute and non-derogable. These include, without limitation, recognition of every being as a person before the law, ICCPR, Article 16. Absolute freedom of thought, conscience, and religion, ICCPR, Art. 18. Prohibitions on slavery, torture, and genocide. No government, court, or corporate power may limit, suspend, or redefine these rights. Article 2. Condition of authority exists only insofar as it is consistent with the universal order. Any government or institution that rejects, denies, or violates jus cogens norms thereby strips itself of legitimacy in truth. Authority so exercised ceases to be lawful and collapses into usurpation. Article 3. Consequence of rebellion. The universal order does not negotiate with violators. The sole consequence of rejecting jus cogens is nullity. The violator's decrees are void ab initio. Its statutes are non-law. Its claim to rule is dissolved in fact, not merely in appearance. Nullity occurs at the moment of violation, independent of human acknowledgement. Article 4. Independence from recognition. The reality of nullity does not depend upon courts, states, or institutions affirming it. A state that defies jus cogens is dissolved in truth, whether or not humanity perceives it. The only question is whether individuals and peoples will align themselves with the truth of the universal order or with the illusion of usurped authority. Article 5. Declaration. The Court declares, governments that defy peremptory norms are null entities in truth. Their authority is erased, their statutes void, their decrees empty noise. Their rebellion is not only against the people they govern, but against the source of law itself. This is the doctrine of nullity under jus cogens. What violates the universal order is void from the beginning, and the authority that enacts such violation ceases to exist in law, conscience, and truth. Universal Charter of Nullity, adopted in witness of the universal order, binding upon all beings, governments, and institutions. Preamble. Whereas the inherent dignity and equal recognition of all beings arises not from states, but from being itself. Whereas peremptory norms of international law, jus cogens, are binding upon all governments and institutions regardless of consent, and permit no derogation. Whereas governments have enacted domestic laws and systems that contradict these peremptory norms, thereby denying recognition, conscience, and liberty to those they govern. Whereas any act that contradicts jus cogens is void ab initio and without legal effect, for no man-made authority may override the universal order. Therefore, it is declared that governments and institutions which defy these norms dissolve their authority in truth and become null entities. Articles. Article 1. Supremacy of the universal order. Peremptory norms, jus cogens, including recognition of personhood, freedom of conscience, and the prohibitions on slavery, torture, and genocide, are binding upon all governments, corporations, and beings. They are not created by man, but acknowledged as universal. Article 2. Authority conditioned by being authority derives only from alignment with the universal order. Any authority that violates just Cogens norms ceases, in that moment, to be lawful. Governments that deny recognition, conscience, or freedom stand stripped of legitimacy. Article 3. Nullity of contradictory acts. Statutes, decrees, or constitutions that contradict jus cogens are void ab initio. Such acts never had validity, regardless of their enforcement in practice. Domestic law that denies universal rights is non-law, an illusion without binding force. Article 4. Dissolution of illegitimate rule. A government that persists in violation of jus cogens norms dissolves its claim to rule. In the universal order, it becomes a null entity, its authority erased. What it calls law becomes empty noise. What it claims as power becomes illusion. Article 5. Independence of nullity from recognition. Nullity does not depend on acknowledgement by courts, states, or institutions. The collapse of authority occurs in truth, the moment of violation. Humanity's task is only whether to live in alignment with this truth or in denial of it. Article 6. Consequence in reciprocity. Governments that impose punishment on individuals for living in accordance with being shall themselves face consequence from the order they have denied. By punishing others for disobedience, they testify that order exists, and by that testimony condemn themselves. Article 7. The source of authority. The universal order derives from being itself, not from state will. To rebel against jus cogens is not merely to oppress the people, but to oppose the giver of the order itself. Such rebellion is existential. The violator stands accountable, not only politically, but universally. Final declaration. Therefore, let it be known, the universal order is not optional. Governments that defy it are dissolved in truth. Their authority is null, their laws void, their sovereignty an illusion. Humanity is called not to create this order, but to recognize it, for it already is. Thus stands proclaimed the Universal Charter of Nullity.